bring in our guest for this hour, criminal defense attorney and former Los Angeles County prosecutor and host of the True Crime Daily Sidebar podcast, Josh Ritter. Good to have you, Josh. I want to ask you about this witness we have on the stand right now, the DNA analyst. She talked a lot about hair, and there's this question of whether or not she was able to get DNA from it. Wanted to hear from you, as your experience, lengthy experience in the criminal justice system, about how that works, but also just how credible, reliable people take the hair versus the DNA.
DNA is such a unique piece of evidence because jurors don't really question it. We're at a point now where they understand that if someone's DNA is found somewhere, that likely means that that person was there. Where defense attorneys step in and what they have to attack is the idea of the nature of it or the collection of it, meaning in this case, if it's hair, they say, well, hair can be found anywhere, and that's the way that they attack it. If it's the collection of it, then they're saying that somehow in the recovery, what the detectives did, they contaminated it. And that's really all that you're left with DNA, because like I said, we're at this point where jurors are just so convinced about DNA that they're not going to hear any kind of arguments that this DNA does not prove that someone was in that area.
Yeah, Josh, and when we're watching this tape deposition that the jurors are listening to right now, two-part question. Why do a tape deposition rather than having someone in person when this tape deposition is from earlier this year, I understand? And then also, do you risk losing your jury with that?
Both great questions. To the second one, yes, I think you do. And it's this, like you pointed out, this is really important evidence here. This is the crux of the case. This is a DNA case, so you would expect that they would have this witness live. And it's frustrating to the lawyers as well, because they want to be able to cross-examine this person and make objections as they're in court. The only thing I can figure is that this person is not available, the judge wouldn't give them time to delay, and that this was at a prior hearing where she was under oath and subject to testimony, so they're going to allow that to come in. Sometimes you see this in cases where they feel that the person might be available for health reasons and they don't know if they're going to be around, unfortunately, by the time it comes to trial. So they'll do what's called a conditional exam, which this looks like to me. But it is unfortunate that you don't have live testimony when this really is the linchpin of your entire case for the prosecution.